Hello, everybody. Good afternoon. My name is John Caddy. I'm the managing partner of the law firm of Caddy Gonzalez. And alongside my partners, Jim Anderson and Rafael Gonzalez, really pleased that you have joined us today on the next iteration of our firm's webcast series today. The subject is the demise of Chevron, Deference, and the effect on Medicare secondary payer compliance. Rafael, welcome. How are you doing today? Excited
Thanks,
about
John.
the subject?
How are you?
Doing well. Jim, welcome to the program.
I'm mighty glad to be here.
Well,
we've got a lot to talk about today, and I think it'll be fun to kick around ideas about what all this means.
I think so too, Jim. And I know that internally here, the lawyers at Caddy Gonzalez, we've been kicking around this issue now for a few months internally, talking about it through a variety of different avenues and channels and applying it to different particular subjects when it comes to Medicare secondary payer. And we thought it was time to talk out loud about it a little bit after a few months post Loper Bright decision. So really glad that folks joined us here today. Just a couple reminders. We're going to plan to go for 60 minutes. We will take questions as we go. If you want to put those in the Q&A box, we'll be monitoring those as we go along. But this is a free-flowing discussion. We do have a PowerPoint, as you see, but we're not necessarily tied to a strict presentation. This is really more along the lines of a facilitated discussion about the demise of Chevron Deference and then what it means for the Medicare secondary payer program in our estimation. Most notably, what does it mean on the issue of workers' comp Medicare set-asides, WCMSAs, going forward? So we're going to plan to go for about 60 minutes. I will share with you in the past, we have had a very difficult time sticking to a strict timing of it. So we're committed to continue talking about this and answering questions as they come in the door. I know we've had sessions go longer than the allotted time. We're happy to hang around and continue talking about this if the interest is there and the questions are there. So guys, Rafael, Jim, why don't we go ahead and get started? And just to level set the discussion, we want to talk through what our agenda is going to be today. Now, we won't necessarily touch on all these topics in this particular order, depending on where the conversation leads. But of course, this is all about Chevron deference, and not only Chevron deference, but also what folks might not be aware of is this notion of Skidmore deference, which has also been on the books now for much longer than Chevron was, and also provides federal administrative agencies some level of deference with respect to the decisions that agencies make with respect to certain statutory and regulatory requirements. From there, of course, being who we are, we're the Medicare lawyers, so we're going to talk about the Medicare Secondary Payer Act and the Medicare Secondary Payer, or MSP, federal regulations that are on point here, specifically looking at 42 CFR sections 411.46 and 47, which in our estimations are the ones that particularly apply to workers' comp Medicare set-asides. We'll also talk about CMS's work comp MSA policy guidelines as outlined in its work comp MSA reference guide that gets updated from time to time. After all of that, how exactly in 2024 do we take Medicare's future interests into account? Is it one-stop shopping? Is it a one-size-fit-all solution? Or are there actually potentially alternatives in different paths that one may take that might get you to the same place at the end of the day? Facilitating that discussion is going to be an analysis of what the U.S. Supreme Court decided this summer in the Loper Bright versus Raimondi decision, which is, for all intents and purposes, has ended the notion of Chevron deference as applicable to federal administrative agencies. We will then go into more of a pointed discussion about how, in our estimation, CMS officials have failed to acknowledge the legal realities that are happening in a workers' compensation claim, especially one that's not necessarily fully accepted. You know, one that is either partially accepted, partially denied, or denied in full. We think there's always been a gap there, and we're gonna talk about what that gap looks like from the lawyer's perspective on this webcast. We also are going to provide examples of where we believe this policy and agency discussion and talking points are inadequate and misguided and perhaps not applicable in the way that the agency wants or wishes them to be. And then finally, we'll wrap up our session today by sharing with you what we believe to be a ripe time for alternative Medicare set aside solutions to be utilized, particularly when resolving a workers' compensation claim. I also believe they apply to liability claims, but the thrust of today's conversation has to do with workers' compensation. So we will address it primarily from that perspective. I'll now take a breath, guys. Any initial thoughts from Jim, you, or Raphael, you, before we dive in here?
Looking forward to it, John. This has been a long time coming. Been looking forward to this conversation for a long while.
Well, I know we're looking forward to talking about it, Raphael, but I'm looking forward to seeing some action in the courts that actually decide some of these issues that we're going to be talking about today. So it should be some interesting times ahead.
Yeah.
All right, guys. So let's dive into it. Let's start with, because a lot of folks might have heard the name Chevron thrown around in this, that, or the other context, and may not necessarily understand the background of what Chevron is. It's not only an oil and gas company, it's actually a 1984 U.S. Supreme Court decision, right, Raphael?
It is, John. The Administrative Procedures Act, right, was born, the ideology in the late 70s, adopted in the early 80s, and this was sort of one of those first cases that tested the authority of the APA. And for the time period during which both the APA and ultimately this court opinion was rendered, there was a great movement to allow the administrative agencies to take ownership of the process of not just the regulatory process, but the interpretation of these regulations. Ultimately, Chevron provided the Supreme Court with the opportunity to say that out loud, right? That where there are ambiguities in a statute, where there are question marks as to the intent of the statute, because it isn't quite clear that it was the administrative agency, because after all, they work on this stuff day in and day out. After all, it is the experts, that sort of subject matter experts, that are putting together the substance of this. And so the Supreme Court at that time in '84 literally came out and allowed the interpretation of the agencies to sort of take center stage, right? And it had to be reasonable, right? In order for the agency to be allowed or permitted this deference, their interpretation had to be reasonable. The statute had to fit within the confines of how the agency sort of looked at it. But at the end of this decision, it was rather clear that it was the administrative agency who sort of ruled the roost, if you will, right? Their interpretation of the statute, of the regs, of how things were about to be provided was center stage.
So this was a 1984 decision from the U.S. Supreme Court, basically giving the federal administrative agencies a certain amount of leeway with respect to how they are acting, interpreting statutes, and promulgating policy in support of those statutes and regulations, right, Raphael?
Yes, sir. Yep. John, and the court here went, I thought, out of its way back then, right, to say that a court of law, right, was not allowed, if you will, to substitute its interpretation of a statute as compared to that which an agency had already adopted, if that interpretation of the agency was reasonable. So at least at the early stages of this particular opinion, again, the agency owned it. It was the agency and not the courts that had all the power to interpret the statute and interpret the regulations as they had been written by the administrative agency.
So since Chevron came on the books in 1984, there are only a small handful of US Supreme Court decisions that have been cited more frequently than Chevron. This has been one of the most cited, most important US Supreme Court decisions rendered in the past 50 years, for sure. Now, this notion of Chevron deference or the amount of deference given to a federal administrative agency, it wasn't born with this Chevron decision, but really was born way back in the 1930s um, in a case decided by the U.S. Supreme Court that was called Skidmore. Um, so think about this. Think about the New Deal under FDR, this expansion of the federal government, the creation of many different administrative agencies to begin to provide services to the general public. There was this Skidmore decision made in the late 30s, which was the first notion of answering this question of how much deference exactly do we afford to this administrative agency and the decisions that they're making on behalf of the American public.
You're right, John. After Chevron, and certainly Skidmore was already at play, but after Chevron, there began a movement to wait a second, this this doesn't quite make sense. We don't agree with the agencies taking such power control over these administrative matters. So there began to be a split, right? When there are Code of Federal Regulations where the process has gone through a system, right, to be able to give the public an opportunity to comment, where there's been maybe judicial review of some of these things. Chevron applies. What happens in situations where there isn't that formal proceeding, right, required? What if it comes out of a memo? What if it comes out of some sort of interpretive agency internal, like a user guide, like a reference manual? What if it comes out of that process instead of a code of federal regulations? Are those interpretations, are those policies also given Chevron deference? And the answer is no, right? Lots of these cases that came along after Chevron made a real big difference between if it follows its formal process, you get the Chevron deference. If it doesn't come through that formal process, but more of an informal internal agency process, then it is provided some deference, but not quite to the high level of Chevron.
And really, at the end of the day, this is why regulations promulgated in an official way following the Administrative Procedures Act, why those are so important at the end of the day for those to become finalized, because those do stand in a different light as compared to agency manuals, opinion letters, policy statements, etc. They've got real teeth to them. And in fact, I know that in our world, in the MSP context, there's an 11th Circuit appellate decision, Bradley v. Sebelius, that provides on point description about the fact that it's regulations that matter most, that reference guides, policy manuals, etc., promulgated by a federal administrative agency like United States Department of Health and Human Service or CMS, those aren't given the same type of deference and the same type of weight under the law.
John, you're right. It just based on these cases, right? It almost seemed as if all of the issues and all of the facts, were being built perfectly in MSP anyway, for this moment to have arrived. Because here we have a statute, right, in 1980, right around the same time of APA and Chevron. And then we have Code of Federal Regulations in some, but not all components of Medicare secondary payer. And then we have, I think, beginning in the 90s, a real heavy duty attempt by the agency not to promulgate CFRs, but to go by way of memorandums and user guides and reference manuals. So it's almost, a perfect setup for the questions that we are exploring today, for the issues, that the court has now recently decided. It seems to me that over the last, 25 plus years, right, that we have been building ourselves right smack into this particular situation that we're talking about here.
So Chevmore's deference, Skidmore deference. We're Medicare warriors. Why do we care, guys? It's because of this statute that's been on the books since 1980, right?
Yep.
Medicare secondary payer, 42 USC 1395 YB2. Medicare won't pay for medical expenses where payment has been made or can reasonably be expected to be made under a workers' comp law plan, under an auto plan, under a liability insurance plan, including self-insurance, or a no-fault plan. It's this statute that we need to look at through the prism of Chevron, Skidmore, deference to better determine what are our obligations with respect to the Medicare secondary payer provisions today.
So, John, some would argue, right, that from the very beginning of the statute, what in the world do those words that are underlined here? Payment has been made, sort of hints at past, reasonably can expect it to be made. Does it hint at future? Maybe, right? So a lot of folks early on argued these are just not very clear. These are ambiguous thoughts here, not well expressed or not well defined. There it is, right? The opening for deference to an administrative agency that then comes through, writes Code of Federal Regulations interpreting those words, or a process interpreting those words, and deference to that specific process and interpretation begins. And I think that's exactly sort of where we got started. As you already mentioned, statute starts in 1980, and by 1983, right, the federal government starts writing Code of Federal Regulations specific to the statute and very specific to conditional payments right off the bat, right? So the process began with those nebulous words right there as we see them on the screen today.
Let's take a step back real quick, Jim, and I want to ask you a question because before you joined the firm here, you were a long-time workers' comp defense attorney representing payers, employers, carriers on workers' compensation claims in Mississippi.
Correct.
For your clients, how did they perceive anything that Medicare says in the form of a policy memo, a reference guide, a town hall call, opportunities where Medicare is speaking publicly outside of a regulatory capacity?
Well, to be perfectly honest, I don't recall the statute or the regulations getting significant attention until after the Patel memo in 2001. There may have been some who paid attention to it, but after the memo came out, there are many lawyers started asking questions. Most of the lawyers that I knew said, "Well, we're so small here in Mississippi, they'll never find us. It won't even apply to us." And of course, we know that that's not the case. And after some attention began to be paid to the regulations that had been passed, and the Patel memo that had been issued, we began looking at the various questions and what does this mean? How do you deal with this? What are we supposed to do now? And as the whole process progressed, what do you mean by workload thresholds? Those are below the thresholds that this doesn't even apply to? Are we just not going to have to worry about any of this? And so there was a whole lot of confusion at the time relating to the Medicare Secondary Payer Act in my practice. I can say that I have seen cases that have settled where the argument was throw in $10,000 for future medical, then he can get his treatment, claimant can get his treatment on Medicare after that. So, it just did not get handled properly. I will confess that. It did not reach the radar timely of the attorneys that I was with and I practiced with on both sides of the law. And after we started getting some direction, it made it much easier to try to figure out what to do. But because everything wasn't covered, there was still much left unsaid, much to be guessed at, rather than having a true path forward.
Jim, for the benefit of some of the newer practitioners or industry members who are joining us today, explain in a little more detail what the Patel memo is. Because some folks might not know Patel memo by the name Patel memo.
It may not. There was a memo that was issued by one of the divisions of the CMS, one of the locations of the CMS, that said, well, why don't we come up with this idea of a Medicare set aside arrangement to take care of Medicare's future interests? Medicare set aside arrangement was not in the statute, it was not in the regulations. And so it became the starting point of trying to figure out what a Medicare set aside arrangement was even supposed to do, how you did it, how you funded it, and all of that. But the memo was not actually one of those things that had even been adopted by CMS. It was issued by a division director. And so it just created much more confusion back at the time than it settled, of course.
Raphael, that was the first instance that we've publicly heard the term Medicare set aside or MSA, right?
We did. There were some of us, that had been sort of roaming around CMS for a long time before then. And the ideology of how do you look at a full lifetime of future medical needs? What exactly do you do it? Do you call it, a life care plan, which maybe was the terminology that I think practitioners were used to back then. So, some folks out west, practitioners at that were the ones who started to use this wording of Medicare set aside allocation, Medicare set aside arrangements. So CMS adopted, I think, the terminology because it sort of, in porpoise, did exactly what they were aiming to do with this new way of making sure that there were dollars post settlement to pay for future medical care that was related to the claim.
Yep. So Jim mentioned this, the fact that this was the first instance of it. It had not appeared in any sort of statute, in any sort of regulation. Here are the MSP Code of Federal Regulations, right here, subparts A, B, C, and D. And for any of you out there that are looking, you've got some free time on your hands, and you just want to double check our work here, you can review the regulations. The term Medicare set aside, I don't think appears anywhere, right, guys?
Still doesn't. 20 plus, 25 years plus, after the Patel memo, still doesn't. There have never been either statutory or regulatory provisions with those words, having been passed or adopted. Yeah.
And I think that's significant. So I'm going to go back one slide, because ultimately the question that we're trying to answer through this prism of deference is the Medicare Secondary Payer Act clear and unambiguous in addressing Medicare future payments and taking Medicare's future interests into account? There's the black and white of the statute right there. We've told you there's no regulations talking about Medicare set-asides, so no statute talking about Medicare set-asides, no regulations talking about Medicare set-asides. The closest we get in the regulations for me is here at 42 CFR 41146, which is a regulation that speaks to lump sum payments of workers' compensation settlements and the effect that those payments have on services provided by Medicare, right? And so 4 subparts A, B, C, and D, basically broken up between the notions of lump sum commutation settlements versus lump sum compromise settlements. Commutation and compromise are terms that are fairly well known in the workers' compensation industry, I think. Raphael, can you touch a little bit on the distinctions there for us?
Sure. Sure. So commutation, right? Generally thought of, you've accepted the claim, you're trying to settle, right? The the flow of benefits, indemnity and medical that flows from that compensable claim. So you essentially take the value of all of that, and that's where you're commuting, right? That's what you're bringing together. In most states, allowable to be reduced to present value, for example, right? As compared to compromise, which already indicates there may be a dispute. Either the entire claim has been disputed, not an employee of the employer, not an accident of the course and scope, or maybe the dispute is about a specific injury and its causative factor is causation from this particular accident in the course and scope of employment. So that ideology, certainly as you indicated, John, not something that's too difficult to find, if you will, in all of the workers' compensation statutes around the country.
So subpart A speaks to lump sum commutation settlements. And if we were to look at that regulation, it would say that, hey, if the parties are settling a workers' comp case as a full commutation of benefits, then the claimant, the beneficiary, must spend down and exhaust before Medicare will pay bills. Fairly easy within the concept of Medicare secondary payer and the purpose of the MSP program, right? To the extent that there's a party responsible for medical expenses, that party should be paying for those medical expenses. And that's exactly what is happening in a full commutation settlement, right? The claim has been accepted by the employer carrier. They are paying out indemnity. They're paying the medical benefits on it. And when that claim is being resolved by settlement on a full commutation basis, that's the settlement proceeds are providing funding for those benefits as part of the settlement. And then the responsibility for payment of medicals is transferring from the employer carrier over to the claimant, the injured worker, as part of that settlement, that clincher. And then ultimately approved by the state workers' comp or industrial commission. The Medicare set-aside concept, as we historically understand it, fits very neatly into that box and that fact pattern, right? And in fact, that's the review process that CMS built out and for a generation now has been allowing parties on a voluntary basis when certain criteria are met to seek Medicare's review and approval of their MSA proposal. But when there's a deviation, when we're not talking about a full commutation settlement, instead there's elements of compromise, then we start to see these gaps appear between the process, the system, the interpretation, and what we see in Medicare's Work Comp MSA reference guide versus the legal realities of what's happening on the ground between the parties trying to resolve that comp claim. And that's where we get into the other parts of the regulation here at 42 CFR 411.46 that speak to how these issues are addressed in a compromise settlement. Now, notably, subpart B is going to talk about the fact that parties can't shift the burden to Medicare. That's inconsistent with Medicare secondary payer. It violates the Medicare Secondary Payer Act, and the regulation is on point, saying that a burden cannot be shifted. But let me just throw this out in the air and let it sit for a few minutes. What if there was no burden being shifted in the first place because the statute never was triggered? Here's the hypothetical I want people to be thinking about as we continue going here. Fully denied workers' comp claim, being settled on a compromise basis. The parties believe it should be a $0 MSA. They're going to Medicare seeking review and approval, and Medicare says, no, we think the MSA should be X because that's what the medical records dictate that future costs of care are going to look like. That's a fairly routine fact pattern, right, guys? Right. That we see getting run through the review process with CMS. My question and my assertion would be that there may not be a burden that was getting shifted there in the first place because no burden ever existed.
John, I think if Medicare was here with us during this presentation today, they would say, you may be absolutely right if there was no settlement, right, of those claims or potentially of those benefits that the claimant may or may not be entitled to. But as soon as a primary payer settles a file, provides a settlement, a compromise settlement for the claim that has been made, right? So a settlement, judgment, award, or any kind of a payment assumes now, under this very limited world that we live in of Medicare secondary payer, that full responsibility, a primary payer now exists. A responsible entity now exists. I think that would be Medicare's position on that particular point, because otherwise you're right? If a denied claim with no payer responsible and no payment ever made, there is, no primary payer there at all. There is no responsible payer there.
And we know that CMS's position. We have heard that in the past, right? Have certainly heard that from CMS officials and see it in the writing in the reference guide. Here's where there is a gap in the logic and the policy statements that are being made is when you look at subpart D of this regulation, which provides very clearly with respect to lump sum compromise settlements and the effect on payment for services furnished after the date of settlement. Medicare's regulation here, its basic rule is except as specified in D2, if a lump sum compromise settlement forecloses the possibility of future payment of workers' compensation benefits, medical expenses incurred after the date of settlement are payable under Medicare. That seems fairly clear to me with respect to what the words are saying there. With the one exception, so we need to look at this exception and understand the context of it. Here's the exception to Medicare's basic rule. If the settlement agreement allocates certain amounts for specific future medical services, Medicare does not pay for those services until medical expenses related to the injury or disease equal the amount of the lump sum settlement allocated to future medical expenses. So guys, what do we think that means? Knowing that this was a regulation coming from Medicare, specific to future medicals, specific to whether Medicare is willing to pay for future medicals.
Well, it says if you allocate a certain amount for future medical, then Medicare won't pay for those services till the money's spent.
In the life of a claim, a workers' compensation claim, right? The injured worker comes into that mediation bargaining table, and a denied claim would say, from date of accident through today, I'm owed X amount of indemnity benefits, and here are the medical expenses, that have so far been borne. That injury still stays with me, and based on my doctors, they're telling me that I'm going to need X, Y, and Z into the future. And so today, trying to walk away and settle all aspects of this workers' compensation claim, past benefits due, and future benefits that if this was a compensable claim, I would be eligible for, right? We are making a demand for all of that. And so it is that with that thought in mind, right, that Medicare's CFR comes into play to say, if in fact you are settling that future medical care, and part of the settlement agreement indicates a future value to that medical care, then Medicare will not pay for those expenses until you've spent down that portion of the settlement agreement that you've allocated for purposes of future medical care related to this claim. So it took the experience of the workers' compensation system, what practitioners were doing on a daily basis when they came in with denied, components of a file, the claims that we're making, and how settlements were being had with regard to that future medical component of a claim, if you will.
So guys, this is one of two regulations that we believe are on point with respect to future medical expenses. The second one is 42 CFR 411.47, which is titled apportionment, right? And it speaks to figuring out, in terms of a compromise settlement, what part of that is really payable for medical expenses versus other items or other items such as indemnity that may be payable as part of that comp settlement. Subpart 1 of that regulation provides that if a compromise settlement allocates a portion of the payment for medical expenses and also gives reasonable recognition to the income replacement element, that apportionment may be accepted as a basis for determining Medicare payments. So this regulation goes towards the burden shifting that we saw in 41146, right? You can't just allocate away Medicare's interest. There is some balance here that needs to be struck between medical and indemnity on a compromise settlement. What do we think about that?
It makes sense, John, right? If the parties have allocated, have given that apportionment some breadth, some detail, right? Then this regulation is respecting what has happened, under that agreement and under that state workers' compensation law. It's in now subpart 2 and the subs that follow thereafter, right? What if the parties didn't break that down? What if there was no apportionment to loss of wages and medical care? Then Medicare has built a specific formula to be able to then give it that same breath, that same life, if you will. And I think in that next slide, John, sub 1 and sub 2 provide the details of what Medicare, right, narrowly defined what happens when there is no specific language in a settlement agreement that apportions the overall settlement into indemnity and to medicals. That's what the answer is.
Yeah, there's a formulaic approach Medicare provides within this regulation as far as how to make that determination, right?
Yep. 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 And let's call it the pro rata share, right? Because this is not new to many practitioners, either in comp or in other areas, right? Depending on the future value or the full value of that case versus what it ended settling up with, right? Depending on all of that. So goes a percentage. And so you multiply that percentage by the settlement value, and there you have it, right? An apportionment of what belongs to indemnity, what belongs to medical.
It's a reasonable, rational approach.
Yep.
Set forth by CMS in official regulations.
Now, John, you know this better than I do, right? That even though it comes after 46, the birth of Medicare set-asides as we know it, right? There it is. We found the seed in 41146, and this follows that. So for those of us who are constructionists, if you will, I've always assumed, I have always argued that 47 very much follows 46 and very much applies to the theories that are being now proposed to us after 46. CMS has argued that 47 has nothing to do with Medicare set-asides, that 47 only applies to conditional payments, right? There's a provision only applicable to conditional payments, that it was never meant to be the formula that you and I are calling for, or that Medicare has built with regard to how do you devise, how do you apportion, right, the percentages between indemnity and future medical.
Yep, that's true. And I'm reviewing the regulation just to make sure I didn't miss it, but I don't see the term conditional payment anywhere within the regulation.
It's not. And
so, go ahead.
The provisions about conditional payment are way earlier in the CFR, right? There is some distance between them here.
Certainly true. Certainly true. So we have these regulations from Medicare. Officially, they've gone through the rigors of the Administrative Procedures Act, the APA, notice and comment making, promulgated. Then we get around to what Medicare uses on a day in and day out basis for providing the settlement community, the workers' comp world, with its thoughts about work comp MSAs, and that's unofficial policy guidance, right? Historically, in the form of individual memoranda that were issued from time to time for about 15 years, later consolidated into one work comp MSA reference guide, which purports to say, ignore all the policy memos. Everything you need to know about work comp MSAs now lives and breathes within this one Work Comp MSA source of the truth, this reference guide, so to speak.
Yep. So here we go, right? And you've outlined it very nicely, John. Those CFRs had processes, federal regulatory provisions that applied as to opening them up to the public, receiving public commentary, a review analysis, a publishing of, and an ability for the public, and those stakeholders to comment and to say something about them, including potential hearings, which were held in Congress, as compared to what you see in front of you here, which are internal in nature, never, gone through that exercise just mentioned of the CFRs. These are all internally produced and very much without that process, right? So I would imagine the argument is that the CFRs hold Chevron deference. These may hold Skidmore deference, right? If again, reasonable, if interpreted to be reasonable as considering the guidelines.
So, in the context of all of that, where we see some gaps and discrepancies between the statute, which is silent about set asides, the regulations, which are silent about set asides, but speak to future medical expenses and benefits and the effect payments have on those, and then what is an extremely robust work comp MSA reference guide that is updated approximately 3 times every year. In light of all of that, then we have to layer that with this notion of taking Medicare's future interests into account, right? Which it's become the benchmark for the workers' compensation industry when they're thinking about these issues.
Yep. That's a good way to put it, John. It's become the benchmark. These are the words that are included in that reference guide. And as you said, it's been amended. It started off with that one single memo, and here we are now with a couple of 100 pages of a reference guide with words like the ones that you're looking at. All of these quotes come directly from that reference guide. So where we started, right, a statute unclear, code of federal regulations that at least provided us an ideology, right, behind that, to now, the details provided to us, not by way of CFRs, but by way of reference guides that I think make it incredibly tougher, right? It builds layers and walls and real prohibitions to doing what I think the original CFR meant to provide us with the opportunity of doing.
Jim, question for you at this point in our conversation. When you were a practicing attorney in the workers' compensation world, providing advice to payers and employers and carriers with respect to a workers' compensation claim in the state of Mississippi, how deep did you back then get into these particular Medicare secondary payer issues with your clients? Or did you take a more hands-off approach to these issues?
Well, we gave advice that we had to consider Medicare's future interests, and how that was accomplished many times was that just changed from client to client based on their own internal policies that they had adopted, their own interpretation given to what was before them from the CMS. So I can't tell you that it was done the same way with every case that we had. It was sometimes it was guessed. Sometimes we had opposing counsel that just insisted that we not deal with it. The Workers' Compensation Commission, of course, had to approve any settlement, but they weren't really skilled in learning the details of all of the provisions of the Medicare secondary payer law and all of its subparts. So they kind of left it up to the attorneys to fix it, and we were often led by what our clients wanted to do in individual circumstances. Can't say that it was the best way to move forward, but that's sort of how it worked.
I think that experience is consistent with other experiences and other attorneys' stories and backgrounds. If we were to poll the audience right now, I think it would be a pretty consistent response that, yeah, it varies from client to client. It varies from case to case, from claim to claim. It's dependent on a lot of different factors, right? What's the risk tolerance level? Um, what is the approach, conservative versus more aggressive? What's the goal here? Are we trying to adopt an approach that's uber conservative, or are we trying to be aggressive with respect to this issue to save cost and save money on a claim? It really varies widely depending on a lot of different factors, and we see it day in and day out with what we do.
Absolutely. We're John. We're running close to the end of our allotted time. Maybe we need to get to the meat of what we think needs to be done.
Yep, let's do that, and we're happy to provide the slides afterwards for people to take a look at. And if you follow us on social media, you'll find them out there also. If you follow our firm, Caddy and Gonzalez, on LinkedIn, we routinely will provide these materials out there for folks to review and take a look at. So the big case that is causing the fuss here is this Loper Bright versus Raimondo case. It has done away with the Chevron decision from 1984, holding that it was inconsistent with the Administrative Procedure Act back in 1984. And it gave unelected government officials too much authority, basically saying that it is the court's purview to decide these issues, not the executive branch of the federal government within the various federal administrative agencies that are there. So with that, here are, Raphael, I believe, some of the quotes from that decision, right?
It is, John, and you're absolutely right. We have now sort of, and this court has done that on multiple cases here over the last couple of years, right? They have switched completely, sort of where the court was 30, 40 years ago, coming around to what I think is a very different conclusion. And in this particular case, they absolutely say it clear. It is not the agency that holds the ultimate responsibility of interpreting the statute. It is the court, right? The court that really holds that statutory authority to be able to interpret it and be able to figure out what it says and what it doesn't say.
So now, guys, let's apply this to what we're talking about here in the CMS work comp MSA context, right? We touched on this earlier in our presentation. The review process that Medicare has established on a voluntary basis in most states, that one can only meet if certain criteria on the file are being met. That review process and these policies have really only focused on the medical components of a particular case or claim. CMS is very reluctant within its reference guide to look at the legal issues that come into play in a workers' comp settlement. And we see the legal issues all the time, and have always noticed a distinct disconnect between the policies promulgated by CMS in this area versus the legal realities of a workers' compensation claim, especially one that's not being resolved as a full commutation of benefits.
We've argued these points, John, right, with CMS one-on-one, sometimes very public at conferences, right, that there is a disconnect between what is really happening on the ground in the life of the case between the parties, and Medicare's only looking at, future medical, which, makes perfect sense when you're CMS and you're at the center of, medical, but it makes no sense, I think, whatsoever to the issues and on the ground to the parties that are litigating a specific file when it is way beyond more than just the medical. So that's been the ongoing, I think, disagreement and argument with CMS specific to these, legal issues that we're talking about here.
So, guys, let's run through a couple fact patterns to share with everyone where this gap or discrepancy really exists, right? So, example number one, we have a permanent total disability claim. Full value of benefits, $500,000 for indemnity and medical. The present value of those indemnity benefits total $100,000. Present value of medical benefits $200,000. So, accordingly, Uh, Plaintiff counsel is demanding $300,000 to settle the claim. However, the employer carrier is pointing out, some of those conditions were pre-existing. The date of injury, we caught your guy on surveillance doing something that probably shouldn't have been doing. And then there's some other intervening acts and events and injuries that really your demand of 300 is not something that we're going to be able to accommodate. And ultimately, they agree to settle for $100,000 at mediation. Parties are going to fund a work comp MSA for $50,000. They submit that to Medicare for review, but CMS comes back with a counter hire for $450,000. Right? It's that counter hire from CMS, which is the only thing preventing the parties from being able to resolve their claim, of which they ultimately agree on every single other detail. And that's a real problem around the country.
I totally agree, John. It's a disconnect, right? The system is an all or nothing, right? You can get a $0 MSA if you meet certain criteria, or else you've got to fund the full value of all future medical care. There is no room in between in this current process by CMS to take a look at a situation like this where there may be defenses, there may be evidence that indicates, that the value of that case may not be what, CMS perceives. That's where I think the blind spot here at CMS is at. That's where I think it's missing, is this middle ground. We understand the zero, we understand the full value, but what if, and I think most cases live sort of in this world right here, what if there are issues there? Can the system do something about that? Does the current system allow for it? The answer is no. In this particular example, and it's a real example, it's a real case, because of this decision, the case was not able to settle.
Tim, back in your days of defending comp claims, on Medicare cases where claimant was Medicare enrolled and you were going to be going to CMS for review and approval of the MSA, how often did you encounter this type of counter hire situation?
Many, many times. Well over 50% of the time there was a counter hire back from CMS. Sometimes not this dramatic. Sometimes it was a smaller amount. But it was something that was quite common. We know from the numbers that CMS released recently that they have increased MSA submissions every year since 2020 by a percentage amount. You could just see what had been submitted, what was ultimately approved. 2023 was the worst of those, where their counter hire was 21.9% higher on average of all submissions to them during 2023. And that's a trend I think that we're going to just continue to see happening without there being any logical explanation as it relates to the claim, except they want to have more money. Well, we know from that CareBridge study back a couple of years back that MSAs are overfunded right now by $2 billion by that estimate in that reported document. So it's one of those things that needs a solution. And that's where I think we have to head.
Jim, that study from CareBridge and Deb Watkins back then really shone a light on the massive amount of overfunding that gets done in the work comp MSA context based on CMS review methodology, pricing methodology, and how historically the work comp industry may have been overfunding MSAs by a large amount. And the recent data shows by an increase of 21%, that's real money over the life of a claim, over a portfolio of claims, just across the work comp industry. That's a big chunk of change that is going and honestly preventing matters like this from being able to be resolved when everybody who's a party to the case wishes for resolution to be achieved. So, guys, with time starting to run short, and I did promise to try to keep us to 60 minutes today, Let's look at the next example that we've got here. This one's a denied comp claim where the employer carrier did provide benefits during the state's statutory pay and investigate period, but after that, and after that period, and after the claim was ultimately denied, did not pay indemnity, did not pay medical at all. Plaintiffs' counsel now is demanding $100,000 to resolve the claim. Employment carriers pointing out that the employee did not have an accident in the course and scope of employment. And that's what they determined during that investigatory period that's set out by state statute that they have a right to do. Case ultimately settles for $30,000 at mediation. Because it was a denied claim, the parties are submitting a $0 work comp MSA to Medicare for review. Medicare disagrees with that and returns with a $150,000 MSA. Again, another situation where the parties fully complying with the state law, but they're not able to resolve this claim because of CMS's policy with respect to the MSA under these circumstances.
And John, I think even more egregious is the fact that here we are almost 25 years after that first memo, and we still do not have an appeals mechanism to challenge CMS on that number. We still do not have a right, for redetermination, reconsideration, a hearing before an LJ, nothing like that available to us under this limited process to be able to challenge this determination that, a denied case, versus $150,000. So that I think is also a component of this, missing the mark of that just a huge component of the equation that has been missed altogether, both the legal aspect and the inability to request review, right, to an appeal, if you will, of this particular decision type.
Yep. At the end of the day, we're talking about MSAs. At the end of the day, are a type of Medicare recovery under the Medicare Secondary Payer Act. The whole reason why we're doing these in the first place is to satisfy this statutory not requirement about MSAs, because we know that's not the case, right? Not a regulatory requirement to worry about MSAs, because that's not the case, but rather this statutory prohibition on Medicare paying medical bills when someone else has accepted responsibility for those bills. All right, so those fact patterns we see across the country, every state that is resolving comp claims, this is happening in light of the Loper decision from the summer that has now effectively killed off the Chevron deference notion. It is high time for legal issues to be considered as part of the MSA process and question that's being asked and answered. Okay, because what's in Medicare's reference guide is distinctly different from what it has in regulations, and the reference guide is not law. And no longer can it be said that this higher level of deference can be afforded to those types of policy positions and interpretations in that form and in that substance, because they contradict and go way beyond what the statute and regulations currently provide for.
Well put, John. I mean, that's succinct and to the point. That's exactly, I think, what the argument would be, right? That if you take a look at the statute and you take a look at the CFRs that went through the rigorous process as compared to what has come from CMS based on these policy manuals and user guides, that there is inconsistency between the two, and that these processes that have now been put in place do not hold the deference, the Chevron deference that has now been killed by Loper. So I think you said it best. That's the legal challenge in allowing all of the facts, the legal issues, that the parties are having to deal with underneath to be able to be part of this MSA process as well. We're not saying that Medicare's future interests do not to be considered. We're not saying that there is, right, a right of the entire system, if you will, to make sure that they don't pay for something related to this claim, right? What we're saying is it's got to be reasonable. It's got to be fair. It's got to be consistent with the facts and the law that's applicable to that state workers' compensation claim in that particular jurisdiction.
And that's where I think
Medicare,
litigation. That's where the process is going to ultimately turn around, is through litigation.
at the end of the day, the parties to a workers' compensation claim have the right to resolve their claim however they agree to resolve it. Medicare or any other federal administrative agency are not a party to that claim, not a party to that action. Certainly, depending on the law, the statute, and regulations that are in place when those parties are resolving their claim, there are certain obligations that need to be addressed. But Medicare and other federal administrative agencies, those rights exist within the confines of the workers' compensation claim that's being resolved by the parties and approved by that state industrial commission or workers' comp board. And that's where our point is today, is that is there a role for traditional, as we've always done MSAs going forward? Absolutely. No doubt about it. The medical matters. It certainly does. But there are circumstances and there are fact patterns where there needs to be legal analysis injected into the decision-making process in order for the right, reasonable, and logical conclusion to be reached, which will help to prevent some of those illogical conclusions that are getting reached by these counter hires coming from CMS under those fact patterns and circumstances.
Agreed, John.
Yep.
I think that says it.
Well, guys, we've done a good job of staying on time. We do have a couple questions in the queue, so I'll go ahead and I'll share those with us, and we'll kick those around. If you're out there and you have a question you'd like to submit, go ahead and put it into the Q&A for us, and we will get around to it. And let's start, guys, with this one. Could you touch on whether any of this legislation is requiring Medicare set-asides in the near future, or is this all about workers' compensation?
So there is no legislation either in the workers' comp scenario or in the liability or no fault situation requiring Medicare set-asides of any sort, right? So not necessarily talking about that. This is now, right, from the Supreme Court of the United States, an opinion that allows us to, I think, argue to CMS these policies that you have been creating, internal policies that you've been creating, do not comport with the original statute, do not follow the original Code of Federal Regulations, right? These policies that you've been creating through memos and user guides and reference manuals are inconsistent with the original thoughts, the original ideas that were placed on paper. If CMS wants to turn around and maybe go through a Code of Federal Regulation process on these different items that they have put together over the last 25 years or so, right? And maybe that's what you were referenced to here in your question, right? Don't know yet whether they will bring on just workers' comp or whether they will go to liability. John, we've had a lot of conversations, haven't we, about CMS going down the road of creating some sort of Code of Federal Regulations on the liability side of the house.
We certainly have, right? That's been an issue of much discussion over the years, right? Today in this environment, we know that, if we're putting on our Medicare CMS hat, while they believe that set-asides in this concept of protecting future interests in liability cases, while that applies and parties over there resolving general liability claims ought to be addressing this issue over there, certainly we don't have nearly the same level of detail, the same level of care. We don't have any regulations about future medicals in liability cases. We don't have a formal review process on that side of the house. We don't have a reference guide for LMSAs. None of that. And really the reason for this discussion today is we're talking about the demise of Chevron deference, but also with an eye towards the new MSA data reporting coming next April, right? And the need for people to understand that, hey, there's going to be mandatory MSA data reporting coming up um, as part of a TPOC report on the comp side. And you're going to need to, separate and apart from the CMS review and approval process, report certain information to Medicare about how you handle the set aside issue, down to the number, the duration, the number of years it's expected to last, whether it was funded by lump sum or structured settlement. If it was a structured settlement, what's the seed amount, what's the annual payment amount, and then some other voluntary boxes to fill in as well. So this is the time is right now to take a step back, pan out, and really think about how you're addressing work comp MSAs as a whole and what makes the most sense, knowing that Chevron deference is no longer in effect. Next question, guys. All right, and our friend Jim is saying this may be beyond the topic, but it is something about which I have been wondering. Is it correct that, regarding future medical treatment, the risk in not protecting Medicare's interests falls on the injured worker, in that his treatment may be denied, but there is no risk to the employer? Is that correct?
Jim, what do you think about that? Does
Well,
it
you
fall on the claimant?
I do think that both parties share some risk there. The BCRC, of course, is going to first go after the claimant to not only deny his treatment, but also to get money back for the conditional payments that may have been made. But I would worry about that injured worker and his attorney turning to the employer and carrier saying, why didn't you do this right? Here you are, you've taken actions and you left my client without any resources. He's lost his Social Security even because of this. I'm going to sue you for bad faith, for handling your claim poorly. It's one of those things that CMS has not addressed. Of course, the potential bad faith cause of action would be a state by state thing, or whether or not it was there. But I do think that there is and should be some accountability on the part of everybody in trying to deal with these issues legitimately. And so I wouldn't say, well, the employer and carrier just have a nanny boo boo. They don't have to worry about it at all. I think it's very possible.
John, I think in this latest edition of the reference manual, CMS used the word False Claims Act, which is, those are scary words, right? And so could the concept of a False Claims Act come back to an employer carrier for either mishandling or not doing something correct? You know, private causes of action, we have seen the case law in that sort of world explode here over the last decade or so. That concept, I think, could be very available to a claimant in this particular situation, right? And as Jim indicated, the request by the claimant to say, I'm going to go back to the judge of compensation claims and I'm going to ask that this file be reopened. That's not the settlement that I thought, right, I signed off on. Those are not the terms of what I understood my settlement to be. So we have yet to see all of that play out, you know, whether these new mechanisms that, you know, are being provided to us, will they encourage folks to go there, right? And if limited to them, will the plaintiff bar go there simply because that's the only option they've got? So some truth in that question. There's supposition because we've not seen it happen. But boy, oh boy, they scare me tremendously just to think about that all of that could be potentially available.
Yeah, we don't know of any circumstances or examples or instances where Medicare has pursued an employer carrier on a set aside issue specifically, right? And we do know that Medicare's preferred enforcement mechanism under these circumstances is denial of benefits. But I guess the question then begs, what happens next, right? Benefits are denied to that claimant. because, hey, you should have funded a set aside to cover this. You should be paying these bills yourself, right? Because when a claim is denied, what's happening there is that Medicare is telling the medical provider, no, we're not paying you back. You need to go collect from your patient because they're responsible for this. So denial of benefits is top of the list. Seeking reimbursement of post-settlement conditional payments. That happens. Okay. So it begs the question, we haven't seen any activity of Medicare going to the other side of the V on those issues, but is it possible that Medicare could try to do that? I sure think it is. Is it possible for the claimant to go back and try to get their case reopened because of this? I think that's possible, sure. Federal False Claims Act, which is all about parties trying to perpetrate fraud against the Medicare trust funds. Is it possible that someone can be facing allegations of fraud being perpetrated under the Federal False Claims Act because of set-aside issues? Yeah, I could possibly see that. That's very extreme. Haven't seen an example of it, but Raphael, to your point, there has been a proliferation of False Claims Act litigation over the past decade, which we know as this baby boomer generation continues to age and more folks are becoming Medicare enrolled, which we're probably going to see another 10 to 15 years of higher enrollments before it starts to level off a little bit. Every dollar begins to matter more as far as benefits being available, dollars being available to pay for all beneficiaries, and making sure that the money coming into the trust funds, which over time has gone down and down based on the number of workers contributing to each Medicare beneficiary, it becomes incumbent on the powers that be to figure out alternate revenue sources to make sure the trust funds remain funded going forward. So is it possible? Yeah, it is possible. But Jim, to your point, haven't seen it yet. But technology's improving, right? This mandatory reporting coming directly from the RRE, the employer carrier. That's a direct link between reporting information to Medicare about the claim and the resolution of the claim and how parties are handling the MSA issue. So, could Medicare pursue a False Claims Act claim against that RRE for failing to report proper MSA money? Not as a civil monetary penalty under the Section 111 regulations of the Medicare, Medicaid, and Estimate Extension Act of 2007, but rather under Federal False Claims Act. I don't know. I haven't sat and thought about it at all. We're speaking out loud about this for the first time, but there may be something to that. If that data getting reported to Medicare with these new MSA boxes is being reported improperly under that statute.
And John, by improperly, you mean underfunding, right? That number, what clearly may not be the right or sufficient number of dollars for future medical care. Because I think that's where this is headed. Now that CMS is going to have accessibility to that data and that information beginning April of next year, I think you're absolutely right. You know, Jim, you and I were talking about the one thing we've learned about Medicare is that they are slow to incorporate, to review, to analyze, but let us never make the mistake. They eventually get there. They learn from the data and they react to the data. So I'm assuming that that's exactly where this is headed, sort of a decision as to whether that number is the right number, whether it matches up with, you know, what were the facts of the case, the medical needs of the file.
I agree.
Here's one thing that I'm interested in with respect to that. What is gonna raise an eyebrow more? Is it gonna be claims that are getting reported with a $0 on the MSA? Or is it gonna be claims getting reported with a nominal MSA number? Which when reported in association with particular ICD-10 injury codes may cause one to question the validity of that number?
Great question, John. Immediately you can think of if a file settles for $500,000 and a zero is reported on that MSA box, that's a flag, right? That I think will awaken everybody to ask what's going on, right? It may be absolutely appropriate, it may be right, but it may not be, right? So that kind of a scenario, a large amount of settlement versus a very low, right, MSA amount may trigger some interest at CMS to internally review that particular case, that situation. So I would imagine that there are going to be patterns like that, John, right? That I think CMS may already know about because they have had now 20 plus years of reviewing MSAs. So they may already know what these fact patterns are. Jim, you called it, right? 21, 22% increase. They've got those numbers all the way back, right, to 2001 when this first system got started. So they may already weigh and grade our answers based on that experience already. It is apples to oranges, but there may be some component of that data that's been sitting there for a long time to be used with regard to the new information we're about to provide them.
I think that's right, and I think the message there is that the reporting next April needs to have some thought behind it. It doesn't need to have just some number that you make up. If there are defenses to the claim that can be part of the analysis and part of the ultimate calculation that's shown, that's one thing. But if it's a fully accepted claim and the number written down is not very realistic, then there'll be consequences at some point, I believe.
Well, and we know historically, guys, some parties resolving workers' compensation claims involving current Medicare beneficiaries may have been trying to think they were cute or gaming the system by settling a claim for, say, $24,500 under that workload review threshold, and then putting a zero on the MSA simply because they settled it under the review threshold. This new mandatory MSA data reporting is going to bring that out into the light because the parties doing that now are going to have to report that zero to Medicare. And how will Medicare feel about zeros in those types of circumstances, especially if it's a fully accepted claim, right? So we are going to see some habits changing, I think, within the workers' compensation industry as time goes on, and the MSA data reporting becomes a real thing starting next April.
So true. And Jim, you mentioned it, right? I mean, we highly believe in this, that the legal aspect, the legal analysis also belongs in that review, in that determination of that, MSA, because that number, John, I think you're absolutely right. It's going to get looked at. It's going to eventually say something to Medicare and they will react to it. We know that immediately they're going to use that number and they're going to put it in that claimant's file. And that's the number at a minimum that the claimant's going to have to prove he spent or she spent before Medicare becomes the primary payer on those ICD-9s or 10s that have been reported through the course of the file. So we know that's sort of the bottom, tier. There may be other reviews and other purposes for that information that I think we're all going to learn about as we go along here.
Yep. So, guys, think about this potential for a second. Obviously, Medicare is going to have the ability to spot check any settlement they want to for these purposes starting in April, right? Can just pick out a claim that's getting reported in their TPOC and look at it willy-nilly without any rhyme or reason to it. But what if there is a concerted strategy behind how Medicare plans to use the data? And what if they begin to consolidate after a few years hundreds of TPOC reports with MSA boxes filled in, and they're going to do a slice of those based on one RRE's submissions to analyze how this one particular RRE, this employer or insurance carrier, how they have been addressing the set aside issue over every TPOC report that has been submitted from April 25 to say April 27. So it's a 2 year period.
Scary ideas, John, because you know that's exactly what they are capable of doing. They have that data available to them, right? And I think if you think it through, if that entity has been reporting claims all along, and for whatever reason Medicare can't put that together, could they ask that RRE for that information that they've been warehousing all along so as to be able to make it readily available, right, to the system and to the world, really, what it is that they have been doing all along. So you're right. The technology today allows them to do all of that, John. They have the capability of doing that. Whether they will immediately, I don't know about that, but I think medium and long term, I think that is an absolute certainty that that's where Medicare is heading with this data.
Guys, a few more questions in the queue, and then we'll wrap it up if there's no other questions that any of the attendees have for today's session. Here's one from our friend Doug Holmes. So, could a state law preempting CMS from second guessing future medical be consistent with LOPR? An interesting question, right?
Very interesting.
It is. It is, right? We know that there are some provisions in the Medicare secondary payer statute that indicates, irrespective of what that state law says, we federal system preempt, right? I think if the provision in the state statute, right, formulates a reasonable methodology of doing that, that would, I think, be an incredible challenge to the ideology as cemented today by CMS. I think it would have to be worded correctly, it would have to be planned out appropriately at the state level. But we know that right now, right, sort of the things are not quite there yet.
Yep. Another question, guys. Let's see what this says. Would the LOPR case apply to the decisions made by plan administrators in LTD cases?
Long-term disability cases.
Does LOPR have any application there?
So I think LOPR has applicability across the board. If there's any federal agency, EPA, and whatever other agency out there, so not just CMS, any federal agency putting out regulations, putting out policy, putting out user guides and reference manuals or memorandums, to guide policy. Any agency doing that, whatever they are creating, is now open because of LOPR, right? They are now open to a challenge that possibly that policy you've created, which didn't follow the rigorous process of a CFR, does not merit, right, either Skidmore or Chevron deference. That's, I think, that any agency now must know that that's an absolute truth, considering this U.S. Supreme Court opinion.
Yep. I think you're on target there. This is a comment, but it's going to lead to a little bit of back and forth, I think, for a couple minutes, which is beneficial to the attendees to hear. One work comp defense attorney has given us this comment. I frequently suggested settlements with medical left open with the employer's right to close medical by funding an MSA as approved by CMS. We could close the claim, but if CMS made a high counter, my client could decide to fund the MSA or leave medical open, rather than being obligated to fund an MSA exceeding the anticipated future medical expenses. Here's why I think that's interesting. And we see that a lot, right? That's a good strategy, but there's one crack there that I want us to talk about for a couple minutes, and that's what's going to happen with that open file at the WCRC with that counter hire MSA out there over time. What will the WCRC do with that, Ralph?
Once they have looked at it, once they have determined what that amount is, written in stone now, right? Now, we used to have to wait a certain amount of time before we could challenge it, right? And now, we are able to challenge, but you still have to prove that the facts of the case, the medical needs, the necessity has become very different than what it used to be. And it is the burden, right? When you submit it, you've got to prove through the medical records that the medical need has substantially changed in order to get Medicare to re-review that old number and changed it. So kind of the old thinking was once CMS reviews it, it is now written in stone. I don't know that I would call it that anymore. You do have the ability, thanks to a certain case that our firm got to work on, to be able to get right new evidence and document to Medicare that the medical needs are very different from what that old MSA that had been established a year or 2 or 3 or 5 ago.
Yep. You have to wait 12 months.
Yep.
But after that, the amended review process from CMS allows one to go back there, present updated evidence and facts proving why the CMS counter hire is not appropriate anymore. But you don't want to leave that hanging out there for eternity, right? You want to address that in some way, shape, or form. That's going to help you get that closed down ultimately. One more question in the queue, guys, and then we're all wrapped up. And this comes from a good friend of ours in Chicago, Illinois, who says, you have provided legal analysis of funding of MSAs prior to Chevron. Does legal analysis now have more credibility post Chevron?
I believe it does.
I do too.
Yeah, I believe this court has said legal matters. The courts have a say. Judges are the ultimate decision makers as to what the statutory provisions and Code of Federal Regulations mean. So I feel empowered by this decision and the legal analysis that we do every day on our files, because I think we can convince and have done so a federal court based on the facts, the issues, the statute, the evidence. So I feel incredibly empowered by Loper. So I think the direct answer to that question is a resounding yes.
I certainly think the analysis is strengthened by injecting an analysis of Chevron, Loper into that process and putting all that in front of a judge and letting the judge decide once and for all what's the proper conclusion. I do think that, and that's part of why we are talking about this today, is that the time is right for legal issues to be part of the work comp MSA. And at the very least, for employers and carriers and other payers of comp claims to have access to experienced MSP legal counsel as part of an approved panel, so that depending on the case, depending on the claim, depending on the facts, there needs to be an ability to have those legal issues analyzed, determined, and ultimately legal advice provided with respect to these work comp MSA issues. So,
Jim, the last bullet point here on our PowerPoint hints at the possibility, instead of going to CMS for approval, going to a federal court, right, for approval of this legal analysis, right, of not just the medical needs, but the facts, the issues, the statute, the case law, and the evidence in the file. What do you think about that? Is there a window there? Is there, sort of bypassing the traditional CMS where we know where they stand in very medically based world over there, and instead going to a federal court based on Loper to say, Your Honor, here's what we propose, how we take Medicare's future interest, considering the legal issues in this case?
I think that's a reality going forward, Raphael. I think that we know that Medicare will not respect allocations made by parties themselves, but it has previously stated that it will respect judicial allocations approved on the merits of the case. We know that the submission process, the review and approval process for work comp MSAs is a voluntary one that's not dictated by statute or regulation. And in fact, you have to have certain qualifying criteria to even get in the door for that process. So availing yourselves of the judiciary for these purposes and obtaining sign off from a federal judge that yes, you are complying with the future medical provisions of the Medicare Secondary Payer Act here in this post-WOPR world. I think that's a real way to move forward and help to insulate yourself and cement what you've done to quote consider Medicare's future interest.
I can see some issues related to some litigation like that. One, the workers' compensation law itself is subject to the approval of the state regulatory authority, and you may have some federal courts who just refuse to get involved in that case like that. It's an interesting idea, but they may very well push back and just say, no, we're not going to do it unless you sued the CMS directly on a deck action or something. You may be able to get around it like that.
Well, Jim, is there any distinction between seeking approval from a federal court for those purposes or seeking approval from a workers' compensation judge for those purposes?
I think you'll find that the agencies, the workers' compensation regulatory agencies, would back away from trying to enforce a federal law, federal regulation. I think they would just not get involved in it. Say no, we're not. We can't speak for the CMS. It's their rules. So, not sure that's the cleanest path out.
Well, guys, I'm looking in the queue. We have answered all the questions, and well, we went 96 minutes today, but we were done with the content within the 60-minute period, or just over that. So I'm proud of us for that. I'm really appreciative for everyone who stuck around to listen to the question and answers and joined us today. Like we said, we will be posting these slides. We'll provide these to you in PDF format for your review and consideration going forward. And we hope that you have enjoyed this presentation today. Jim, any final thoughts for everybody before we sign off?
Just delighted to be here and have the opportunity to talk about some new ideas in light of the difficulties that the whole industry struggles with on a regular basis. Hopefully we'll be in a position to provide you with some assistance as we go forward and begin working through some of the options that we have talked about.
Thank you for that. Raphael, final thoughts to share?
I echo those thoughts. Always appreciate being able to discuss these important issues with you guys and for the folks who entrust in us to provide leadership and thought leadership on all things MSP. So thank you so much for attending.
Yep. Thank you, Raphael. Thank you, Jim. And thank you to everyone out there. We really appreciate you tuning in today. Follow us on social media, on our LinkedIn account, on our Twitter X account. You get live, real-time updates about these types of issues, and that's where we'll also announce our next webcast when we're ready to put that on the calendar. So that's it for today from Caddy Gonzalez. Thanks again for joining us. Until next time.